Good afternoon. Thank you to Dean Kennedy and Chair Balboni for the invitation to speak to you today, and Chairman Balboni for those very kind words. I wanted to also express my deep appreciation to Wayne Budd as well for his role in extending this invite on behalf of the law school. As many here on the dais know, Wayne is a longtime trustee of New England Law and himself the recipient of a New England honorary degree. I'm proud to say he's one of my mentors and a mentor to so many in our Commonwealth Bar. So Wayne, many, many thanks. Thanks as well for the honorary degree that this institution has just bestowed upon me. It's been made all the more meaningful to me because I was awarded it in the company of 3 people who have dedicated their lives to service. To Mr. Brett, a special shout out to you, since Special Olympics is very near and dear to my heart as my son participates in it year to year. And I don't know if everyone caught it, but the pastor is a minister, a doctor, and a lawyer. And then finally, General Woodhouse, you inspire all of us. Thank you very much for your service. It is a true honor to be made a member of the graduating class of 2026. Particularly since I've had the privilege of having a number of New England students in my chambers during my 15 years of service on the U.S. District Court for the District of Massachusetts. Each of these interns has been outstanding. To a person, they've been smart, eager to learn all that they can about federal courts, and destined, I know, to be valuable members of the bar. This spring semester was no different when graduating 3L, Elise Lynn, was my intern, and I'm going to embarrass her. Where is she? Come on, Elise. She did wonderful work over the past few months, and if her work ethic, judgment, and poise are an example of this generation of attorneys, then our profession certainly is in good hands. To Elise and all of the graduating members of the class of 2026 and your proud families, I am honored to be among the first to congratulate you on receiving your law degrees today. I'm also deeply humbled at the prospect of sharing remarks with you on such a milestone in your lives. It is hard for me to fathom that it was 32 years ago that I sat in your shoes, awaiting my own law school diploma, contemplating the bar exam at summer's midpoint, sorry to mention that today, and looking forward to the start of my legal career. But the legal landscape that you are facing looks very different from the one I was facing in 1994. It's different in at least 3 ways: in where you do your work as attorneys, in how you're expected to conduct that work, and the way in which our profession thinks differently about resolution in some civil cases and reentry in some criminal cases. First, even several years after the pandemic, it is unlikely that you will report to an office to work every day, even as the demands of clients and attorney hours have increased. Now, of course, there are virtues to thinking of a workplace in broader terms. Time previously spent in commuting every day can be used more productively for work, and technology, for better or for worse, makes all of us more accessible in many different settings. Significantly, there is perhaps a better chance in this work configuration that you can invest the time you need for work and still preserve time for the elusive work-life balance that those of you who spent your years here balancing full-time work and law school studies know all too well. Shout out to the evening division. But there are pitfalls as well for this new conception of the workplace, particularly for new attorneys, I think. There's less opportunity for in-person interaction with more senior attorneys. It may take more effort on your part and their part to cultivate mentorship. particularly when you can't as easily knock on the door down the hall for advice, be asked into a client meeting at the last moment, or pick up an assignment merely because you were standing in the hallway at the right or wrong time, all of which, I'll tell you, for me as a freshly minted attorney, blossomed organically into greater opportunity and exposure. You, more than my generation of lawyers, will have to be more proactive about getting meaningful feedback about your work, engaging with the bar outside of your workplace, and for the inspiring litigators among you, tagging along to court to see advocacy in action. Please don't let the flexibility of the post-pandemic workplace rob you of the opportunity to, yes, come to U.S. District Court or any of the courts of the Commonwealth to watch oral arguments, to take a leadership role in a bar association, or to participate in the civic education programs that those associations and our own court put on with the critical assistance of attorneys. Another change in the landscape that you will encounter that I did not when I graduated is the way in which you will conduct your legal work. I don't have to tell this audience that AI is changing the way much work, not just in the legal realm, is being done and is expected to be done. Certainly, AI can facilitate legal research, summarize voluminous discovery, and by doing so, save attorneys and their clients time and money in locating source material. But the danger is when attorneys use this new tool in the toolbox as a substitute for their own judgment or an abandonment of the ethical obligation to ensure that there is a viable legal basis for their arguments. That the filing of briefs with hallucinated case sites has gotten so much attention from courts is not a blanket rejection of the use of AI, but a deep concern by judges like me about the integrity of a judicial process that necessarily relies on the good faith of attorneys' representations to the court. And I'll tell you, there are no shortcuts to becoming a great attorney. You must grapple with legal questions that sometimes have not been answered yet by courts. You must give the best legal advice, sometimes with imperfect information from often imperfect clients. You must grapple with complexity and nuance that often involves asking more questions, listening more carefully to your clients, and making informed decisions about where the law is headed. It will be your challenge to harness AI ethically, to increase your broader access to information, but not as a substitute for what must be your own independent, learned counsel and judgment. Lastly, the legal landscape that you will encounter upon your graduation that is different from mine is the way in which our profession, and certainly our courts, have come to think differently in some instances about civil case resolution and reentry after incarceration. Earlier this year, I was reviewing an ADR plan document from when the court was first rolling out its mediation program approximately 26 years ago. I was struck by how much of that plan was devoted to explaining ADR, that is, alternative dispute resolution, since it was still a new concept then, and ADR programs had only been mandated for federal district courts in 1998, when I was still a newish attorney. Today, the consideration of such alternatives is now a routine part of what attorneys discuss with every client, particularly as it concerns the cost-benefit analysis of the cost of litigation versus the likelihood of recovery. Even as I, along with my fellow judges, stand ready to try any case, we raise the availability of ADR and mediation both in the early and late stages of civil cases as part of the well-settled landscape that you will enter. As to criminal matters, you're entering a landscape where over the past few decades, the court system is not just thinking about the sentence, the criminal judgment, as the endpoint. Instead, we've added a focus on working to ensure that after serving their sentences, defendants who have struggled with drug addiction have a better opportunity for successful reentry. As one example, our court's court-assisted recovery effort, or CARE program, founded by one of my colleagues, turns 20 years old this year. Over the past 2 decades, CARE has supervised defendants through a year-long intensive program as they re-enter the job market, return to family, and actively address substance abuse. This is one of the ways that innovative approaches have altered the legal terrain that you will enter. Now, even as the landscape has developed in the 3 decades since I was in your shoes, there's one important feature that has not changed and has become more important in recent years. That is the importance of adherence to the rule of law by all of us, by lawyers, judges, and everyone who believes in a great democratic society like ours. The rule of law is at the crux of what you've studied here at New England, put to use in clinical work and pondered in articles for the law review. It's what guides those of us who serve on the bench, acts as the guardrails for effective advocacy by attorneys, and provides appellate review for those who disagree with our decisions. But when dissent is in the illegitimate form of violence or threats of violence against those with whom we disagree, then the rule of law itself is in jeopardy. This is particularly true for judges, who are called upon to apply the rule of law and decide often contentious issues. As Chief Justice Roberts noted at year's end in 2024, reactions to judicial decisions that include, open quote, violence, intimidation, disinformation, and threats to defy lawfully entered judgments, end quote, are areas that, open quote, threaten the independence of judges on which the rule of law depends, end quote. Our district, the District of Massachusetts, has not been immune to such inappropriate responses, which in some cases have come in the form of threatened acts of harm and violence against judges and their family members. This should be concern to anyone and everyone who, like you, understands that the rule of law is what protects constitutional rights, provides just relief for litigants' claims, and justice for criminal conduct. Now, class of 2026, if you're still listening to me, you may think that my remarks today are not the rosy platitudes that you were expecting. But I hope that the true picture that I've tried to paint for you does not cause you despair, but inspires you. Having gotten to know some of you, and I'm back to Elise here, I'm confident that you will be inspired and recognize that for each of the challenges that I've mentioned, there is opportunity for you, the class of 2026, to have an impact on the legal landscape that you are inheriting. You will enter the bar soon. I understand that over 70% of you have applied to the Mass Bar, so I look forward to seeing what you do here to advance the rule of law in this Commonwealth. But whatever field you choose, whether in public service or in private practice, whether in practicing law or working in a law-adjacent field, I hope that you will be an engaged member of our profession, foster adherence to high ethical standards, call out threats to the rule of law from whatever source they might come, and encourage others to take the same just stand. I thank you very much for your kind attention this morning, this afternoon, and congratulations to you, my fellow New England class of 2026 graduates. Thank you.